Viewers, before I play this clip, watch the power of plain language against institutional confusion. Senator Malcolm Roberts does what the bureaucracy appears unwilling to do. He brings the question back to male and female reality. He asks whether Australian sex discrimination law now treats a biological male who identifies as a transgender woman as legally included within the category of women. And that question is not hateful, it's necessary. Because if the law cannot distinguish between biological women and biological males who claim female identity, then women's sex-based protections are no longer secure. Dr. Anna Cody speaks from the current legal framework, but that is precisely the concern. Her position appears to defend a system where gender identity can sit inside the legal category of women, even when the biological reality is male. And that creates a collision Senator Roberts is exposing. Female privacy, dignity, safety, sport, shelters, prisons, recovery spaces, lesbian associations, and sex-based boundaries all depend on legal clarity. If the word woman no longer securely means biological female, then women's rights are not being protected with certainty. They are being filtered through institutional interpretation. And from a divine sovereign restraint perspective, male and female are not categories invented by Parliament, commissions or courts. They are created realities human authority was meant to recognise and protect. Senator Malcolm Roberts' questioning matters because it forces the institution to face the severe issue. Can the law protect women as women after it has made the legal category of women expandable beyond female reality?
Thank you for appearing again today. Could I speak with Dr. Cody, please? Hi there again. My first question seeks to clear up your role in Tickle versus Giggle. You did not prosecute the case and you did not fund the case, yet you presented a legal opinion in an amicus curiae, friend of the court submission. Is that correct?
That is correct, that our role was as amicus curiae to assist the court to understand aspects of the Sex Discrimination Act.
Thank you. For clarity, your submission set out the law, the Discrimination Amendment, Sexual Orientation, Gender Identity and Intersex Status Bill 2013, passed under Prime Minister Gillard. It changed the definition of woman, which can now be a person's self-described gender identity, including appearance, mannerisms or other gender-related characteristics, with or without regard to the person's designated sex at birth. You argued Tickle was a transgender woman with female legal recognition and presentation, and therefore the treatment from Giggle was properly characterised as gender identity discrimination. Other sections around special measures to promote gender equity, including Section 7D, were subordinate to the overarching definition of gender in the Act. In simple terms, is that your advice to the court?
No, Senator, it wasn't. We did not make any submissions on whether or not Ms Tickle had been discriminated against. Our role was to assist the court to understand the constitutionality of the 2013 amendments and then also to discuss meanings of sex and gender identity within the Act, also the meaning of special measures and how they would apply, as well as any role for exemptions.
Okay. Thank you. Amicus curiae, pardon my Latin, is a neutral or advisory role to help clarify legal questions. Are you neutral in the Tickle versus Giggle case?
Our submissions were to assist the court to understand and to interpret the Sex Discrimination Act. So yes, that was our role as a intervener to assist the court.
Are you neutral?
Our role was to assist the court to understand the provisions of the Sex Discrimination Act.
Are you neutral?
Senator Roberts, the Commissioner has answered your question.
How can you be neutral when you marched into court at the head of the scrum of people on the Tickle side of it? You are making a clear statement in that action of support of one side of this case, a personal show of support not appropriate to an amicus curiae role. Were you not?
No, Senator. We took seats on the only space that was available in the courtroom. That's why we were sitting on the right-hand side of the courtroom.
I saw your comments in the publication Out in Perth in April 2024 where you said, quote, "We stand with trans communities and will continue to advocate for their rights and the rights of women." You are making a very clear distinction here between the rights of women and the rights of transgender women. Do you agree your comments amount to a statement that trans women are not women?
I'm sorry, Senator, could you repeat that question?
You talk about trans women and you talk about women. Doesn't that show that they're different?
Transgender women are a subset of the broader category of women. Women includes First Nations women, women with disability, older women, younger women, women from culturally, racially marginalised backgrounds, and trans women, lesbians, non-binary, sometimes would include in that as well.
Okay, I'll come back to that. Moving on, this report, titled Equal Identities plus a long subtitle, was published under your name as Sex Discrimination Commissioner. Can I confirm your official position as contained in this report is that trans female exclusion from sex-based spaces or services, for example, women-only apps, shelters, sports and bathrooms, is unlawful gender identity discrimination under the Sex Discrimination Act, Section 5B. Is that correct?
No, that's not correct, Senator.
It's not correct.
That's not what the report refers to, and that's not my position.
Section 42 of the Sex Discrimination Act, which provides an exemption specifically allowing sporting organisations to exclude someone, including a trans woman, from a competitive category of strength, stamina or physique matters in that sport. I haven't heard your office mention this exemption, which is directly relevant to controversies surrounding or around, for instance, the Flying Bats Football Club. If you do in fact provide independent advice as you claim to do so in the Tickle case, why haven't you advised the opposing teams that keep getting injured that there is an exemption to protect them in the Act?
It's not our role to provide advice to individual parties. We conciliate complaints if someone makes a complaint of unlawful discrimination, and we advocate for the human rights of all people within society, recognising that all people have a right to equality, respect and dignity. That's human rights law, and as it applies in Australia.
Do you want Section 42 sport exemption removed from the Act?
No, Senator. It has a legitimate place to play where strength, stamina and physique are relevant to a sporting activity.
Why strength, stamina and physique? Is that a distinction between male and female?
The words are strength, stamina and physique, so different sports have different requirements around each of those, and so that's an important exemption that when the Parliament passed the Sex Discrimination Act, it included to ensure that sport enabled people to participate fully within it.
Let's move on. Your report recommends repealing or narrowing exemptions in the Sex Discrimination Act, such as Section 43A, that allow sex-based or faith-based exclusions. Broad religious exemptions are criticised as creating uncertainty and legitimising exclusion. What right do you have to present an amicus curiae brief when you are already clearly heavily biased in favour of Tickle and opposed to religious freedom?
Our role within the Australian Human Rights Commission is to advocate for the human rights of everybody within our community. That is a part of our role as a national human rights institution. Our role as amicus curiae is a different role. We're not advocating in that situation, but rather providing clarification to the court on the meaning of the Sex Discrimination Act.
I note the Gillard government legislation that caused this ludicrous outcome passed on the voices with Senator Birmingham, head of the Liberal Party in the Senate, on behalf of the Coalition, calling the bill, quote, a very welcome piece of legislation, and end quote, and specifically supported the absurd and illogical gender identity provisions. So I'm just clarifying the record. Dr. Cody, what is the difference between gender identity and gender? Because in your answers to Senator Cash, you implied there was a clear difference between gender identity and gender. What is the difference?
I was referring in my answer to Senator Cash to how sex is understood within law, and in terms of the protections provided in discrimination law. Sex looks at three aspects. Those are biology and physical characteristics, as well as how someone presents themselves, as well as their social recognition. So those are the three aspects that relate to how sex is understood under the Sex Discrimination Act and within discrimination law more broadly.
And what about with regard to the differences between gender identity, or people who identify as a gender, and the real gender? Does it apply there?
Gender identity is within the Sex Discrimination Act. I can refer you to the provision for gender identity, but I don't have it to hand right at the moment.
So gender identity is a construct of the law. Is that correct?
Gender identity is protected as a protected attribute within the Sex Discrimination Act. It's not only an aspect of the law.
So if someone introduces a bill and it gets through the Senate and the House that says men are the same as women, that's the law. Is that correct?
It's up to the Parliament to pass its own laws, Senator.
Right, so the Parliament can say men are the same as women, end of story, that's it. So, okay, thank you. What is the meaning of gender identity and gender?
Gender identity, if you'd like me to refer under the Sex Discrimination Act.
What's that? Could you read it out, please?
Yes, certainly.
Senator Roberts, I'm going to share the call after this too.
Okay, I have another set later.
I'll allow Commissioner Cody to respond to your question, then I'm going to share the call.
Yeah. Could I come back to me later?
Gender identity within the Sex Discrimination Act means the gender-related identity, appearance or mannerisms or other gender-related characteristics of person, whether by way of medical intervention or not, with or without regard to the person's designated sex at birth.
Thank you. The key word would seem to be or. I'm not a lawyer, I'm not a judge, but that would seem to be the key word, and it's used twice in the definition, separating the three characteristics.
Thank you.
So you don't
Senator
have to
Roberts.
have a gender. You can be whatever you want to be if you identify as such or if you dress as such. Thank you very much.
Thank you.
The exchange here proves why Senator Malcolm Roberts' questioning matters to Australia. He forced the issue back to plain reality. If a biological male who defends and identifies as a transgender woman can be legally treated as a woman under the Sex Discrimination Act, then women's sex-based protections are being placed in direct conflict with gender identity interpretation. Dr. Cody's position may reflect the current framework, but that is precisely the problem. The framework now appears more capable of explaining gender identity inclusion than defending biological women with clarity. Malcolm Roberts' accusation of partiality should not be dismissed. It exposes the appearance that the Commission is more fluent in defending the legal pathway than in protecting women as created female reality. And that's not neutrality. The institutional preference operating beneath anti-discrimination language, and that's what it is. It's an institutional preference operating beneath anti-discrimination language. Women's rights were built on female bodily reality, privacy, dignity, vulnerability, safety, reproductive difference, and spaces where male access carries distinct risk. The law cannot protect those realities if it refuses to name them clearly. And human authority is not sovereign over male and female. Parliament may amend language, commissions may interpret statutes, and courts may apply them. But none can dissolve created reality without producing injustice. So here's the final question. If the office responsible for sex discrimination appears more able to defend, say for instance, Roxy Tickle than defend women, trans women, let's say to defend trans women rather than be specific, than defend women, what is being protected? Women or the framework that made women's protection negotiable? I'm Dr. JWA, theologist. Like and subscribe to help me, comment to educate me, and share the video to help somebody else.